We'll start.
Yes.
Yeah. Yes, yes. Thank you, madam. Thank you, Intellactual madam, for introducing me to this new group. First, let me thank organizer for giving me an opportunity to spare my time with the people who are interested in IPR. I hope my slide is visible. Yes. Huh. Yeah. So, uh, just I will take you. This is the for a beginners I have written because, of course, the students and staff who are here are already aware about the scope of IPR in India at present. IPR, that is intellectual property rights. There is a big scope for we Indians to have our property as IP property, intellectual property. So let us understand what is this IPR, how many types of IPR are there, and how to protect this IPR, and what are the benefits and choice. So my today's contents of this topic is what is IPR, little about history I can avoid, and what are the forms of IPR, different forms of IPR, that is patent, trade secret, PBR, that is plant breeders' rights, and copyrights. And what are the benefits of this IPR and choice of IPR. I hope my slides are moving, right, madam?
Yes, ma'am.
Yes. So all of we know that the property is nothing but bank balance is a property. We say home, villa, or field. Like these all are property we say. But those property we can transfer from one to another. Whereas intellectual property cannot be. Intellectual, the term itself indicate it is a creation of the mind. That is invention. It may be a literary, means, or it may be artistic works. That is what generally we call in engineering as a designs, symbols, some names of the organisms, images and designs used in commerce. That is very, very important here. That means which should be commercialized or which should be marketable one. So those creations comes under IPR. There are many different definitions are there. What is IPR and there? Okay, India is not a now we are not into that, but only we are understanding, especially engineering
Great
students
students
and
and
engineering
engineering
staff.
staff.
Now
Now
we
we
are
are
entering into this field, IPR field. But India, no. India has already has a lot of innovations. So these novel techniques, but retained within the families. All of we know, no? Here it near Harkal. If you are belongs to Bagalkot or Jamkhandi nearby Bagalkot, there is one place Harkal's place. So where one person is there, he gives some plant extract for the fractures. So many people believe it, and even a lot of, I mean, it is a very good remedy he is giving. But he is unable to disclose it, or he is unable to scientifically prove it. It is what we call traditionally they are doing it. But that is continued within the family. Okay. And there was no protection for that, because if somebody who is good in plant, if he goes and if he understand what is the plant extract he is giving, then anybody can start that, right? Anybody can start. So that Harkal person, I don't know exactly his name, but place is Harkal, I know. While going to Bilgi, there is one place. Example I'm taking. So he is not having a protection. He can keep that secret. But if that invention or innovation, if comes under IPR, that there is a protection. IP protection will be given. So today we are understanding what is this protection. Okay. So in India, in 1856, the Act of Protection of Inventions are started. That is under British Patent Law, 1952. And Patents and Designs Protection Act passed in 1872, Protection of Inventions Act. These all are like acts simultaneously they have started. These are acts made. Okay. Then there is a WIPO term is there. WIPO is like World Intellectual Property Organization. World, where this all comes under WIPO. So according to the WIPO, what is intellectual property? What he defines is intellectual property is a creation of the mind, that is innovation. All this I said already. So then, what is creativity? We say no, in the definition we write the creation of the mind. What is this? The creativity is the ability. Ability to what? Ability to think. This is all what creativity is, the ability to think or to come up with a new idea, or it is the ability to design new inventions, it is the ability to produce works for art, it is the ability to solve the problems in the new ways, differently, or develop a new ideas based on the original knowledge, or we will use the word novel or unconventional approach. The conventionally, that one example what I said is this Harkal person, conventionally he is doing it. But what we can do is, or suppose what he can do is, suppose if he discloses all this to the IP, that is Intellectual Property Office, where he can get the what you call it authority. That means only he can use that, nobody others can use it. Otherwise, somebody can steal it. If they steal, others can start his activity. Okay, so the same thing, if we do it differently or unconventionally, then that also is called as a creativity. Okay, then how this activity starts? Always the students will be having the question in their mind: what is this IP? How to get this property rights? Intellectual property rights. It is the rights given by the government to the innovator. It is the rights given to the innovator by the government. Who will give this IPR? And the government will give these rights. To whom it will be given? To innovator. Who is innovator? The person who does the work differently and proves it has commercial viability, commercial value. Okay, so for this activity, see, always engineering students are very creative students. We believe it. We teachers believe it. Even MBA students also. They are very creative. But this creativity, how it should convert into IP. So there is a chain of activities are there. First step we call it as a creation. First, something you have to have. Creation is like idea also. Device, design, process, anything you have to create it. That means the first. Second is innovation. So you should prove it. It is innovation. See, there are two terms: invention and innovation. Invention is discovery, which is not existing. So that if we discover, then we call it the invention. That scientist will do it. But innovation is doing it differently is innovation. It's in a broad aspect. I said, what do you mean by innovation? Innovation is the things are existing, but we are making it more comfortable, more useful, more reachable. Like values we are adding to that existing one differently. For example, now I have a pen, right? Pen I have. Everyone is having a pen, and there are those so different pens are there. But if I am a person or office worker, where I have to write, always I will be writing this, my work itself is a writing. So my hand may pain. My hand may pain by holding this pen, which is a stick, right? Pen like. For them, how I can make it differently so that that person will not be having a pain in his hand, in his finger. That means existing pen concept is there. How you do it differently so that you are solving the problem of the person who is having the ache or like pain in the finger when he writes continuously. So that is called innovation. Things are available, but there are some problems. That problems you have to identify and you have to try to take it to solve that problem differently. That is what we call innovation. And this third step or third link in this activity is commercialization. See, you may have that pen where differently you want to design it differently. You have some technique, you have some innovation where you are coming out with a new item. But this new item should be commercialized, you know. People should take it. See, nowadays, that pen, how many of office workers are writing with the pen? No, everyone is computerized. Even if you go to villages also, all government offices are having a pen. Then you should think it. If I make this pen, can it be commercialized? Any buyers are there, right? So commercialization point is very important. When you want to get these rights now, you have to prove this. It can be commercialized. There are buyers in the market. Okay. Then fourth is like protection. Protection is government will give this protection. There are some criteria. If you reach that criteria, or if you are under that, if you meet that criteria, then the protection will be given by the government, by date office. Okay. Then there are different forms of IPR. I hope it is clear what you mean by IPR. My slides are moving now. Protection of IPRs, right?
Yes, ma'am.
Yes. So broadly, intellectual property rights are broadly divided into 5 categories. Broadly means forms of the IPR we see. What are the different forms of or different types of IPRs? There are 5 types. One is patent, second is trade secret or trademark, third is PBR, that is plant breeders right, then copyrights, industrial designs. And these are the IPs. Means these all come under IPR, intellectual property rights. You can have these 5 different forms under IPR. Got it? Patent is one of the IPR. But people always think patent is the IPR. No, it is one of the form. Copyright is also another one. Plant breeders right, trade secret. So briefly, I am taking this. What is this patent? All these 5 we will discuss. What is this patent? Patent is a protection given to innovator, that a patentee we call, for an innovation for a limited term. by the government for disclosing his innovation, his or her innovation, and to exclude others from using your invention. That means, see, there are terms which I have highlighted here. The patent, what is patent, and the definition itself indicates it is an innovation. Who is doing this? We call him as an innovator. Who will give this right? Right will be given by the government to the innovator. For what he will give? For disclosing his innovation, and why they will give means to exclude others. Because if I have invented, I will tell my example only. We have developed one soap that is which is able to remove the ticks from the cattles. We got a patent for that. Then anybody can do it, no? But it's a simple process. Something formulations we have made, it is perfectly working on the cattles. When they apply this soap regularly, it is able to remove the ticks. Ticks means unne we say in Kannada. The cattle sigi, pet sigitavalla. So that then anybody can do this. So first time we have made this formulation, but many our students know that, many visitors are coming, they also know that because we disclosed it. Anybody can start this. But if I have taken this as a patent, that means the rights are given for me to make that soap, that whatever particular formulation I have written now, so that formulation belongs to me only. If somebody start it, they cannot, it is offense. They cannot take my formulation, even though it is disclosed. Disclosed means everyone knowing it. Okay, that's what we call a right. I hope it is very clear. What do you mean by rights? Rights means authority. None bitre ಬೇರೆ ಯಾರು ಅಸೋಟ್ ಮಾಡುವಂಗಿಲ್ಲ. Even though they know how to do it, what is the formulation anta. There is some term, that is what we say, given for a limited term. In India, it is 20 years only. Today, if I apply for patent of them from my innovation, then from the day of application, only 20 years, I can enjoy this. After in 20 years, it is everyone's. That is the reason why what you call like products are changing, you know, right? Because after 20 years, the same soap, I will change it. Because after 20 years, my soap will not be sold. Some other marketing people will come and they will do it. Something will happen. So my business may come down. Okay. So patent is, once again I will repeat it, patent is a protection given to innovator. Who has done it, only he will be, who is applying, he will be getting that rights. It will be given by the government. Why they will give means to exclude others. Exclusive rights they are giving me. ಬೇರೆ ಯಾರು ಮಾಡಬಾರ್ದು, ನೀವು ಅಷ್ಟೇ ಮಾಡಬೇಕು ಅದು ಅಂತ. Okay. So owner has a qualified right to use the invention. Only owner has this rights. He can give it, but others cannot do it without his permission. Okay. Then patent as invention means source of recognition for the innovator, incentive to develop. Why patent are? It is like we say, why I have to go for patent. See, when you go for patent, that soap, if you have a commercial value of that soap, I can commercialize that soap, or I can give license. So being a staff teacher, I don't want to start my industry, but what I will do, I will transfer my technology to somebody others. That's what we call licensing. I will give it to some other person. If he is ready to do it, I will license him. Name, company name or trade name, nothing will be mine. Only I am licensing to XYZ. He will take my license and he can commercialize that product. But for that licensing, he is paying for me. That is what we call the royalty. Continuously, that royalty, there is no hard and fast rules that this much percentage we have to take. No, it is all agreement. You have a rights. You can ask him 50% share or 50% profit will be mine. Okay, any agreement we can. On that agreement, we can license it, or yearly this much amount. And what is other advantages? Or I can start my own company. That's what we call startup. Okay. So there will be many imitators. My soap will be imitating by others. So that can be protected if you go take the patents. Then which one you have to take the patent? And there are some patent requirements. These 5 are the patent requirements. First, eligibility, what we call. If you want to apply for patent, these are the eligibility. One is novelty. We all know what is novelty means. Very new, which is not known to others. First, ನಾನು ಮಾಡಿದ್ದು, ನಾನು find out ಮಾಡಿದ್ದು ಅಂತ novelty, which is not existing, which is not known by others. That is what we call novelty. Novelty is required. When you apply for patent, the novelty, okay, what novelty you have this in this. The patent may be product, patent may be process, patent may be even what you call it, service. Broadly we say service sector is there, processing sector is there, product is there. You can develop a process, especially the mechanical people and all, they will develop a process. That process will be given to some industry person. He will make that process into many products. Process can be patented, product directly. We do the products. We biotechnologists, we have a product. Okay, we can have a product. Or the IT people have a service because they will develop some apps which is kind of service sector, comes under service. So anything which is have novelty that can be patented. And inventiveness. Now I said no, innovation should be there. You have to prove which is new than which is existing. ಸ್ವಲ್ಪ difference ಇರಲಿಕ್ಕೆ. You have to prove that what is innovation in your product. I said pen now. For what purpose you are making designing this pen? So that inventiveness, you should explain it or you should prove it. Then third is industrial applicability. Whatever you make it, some industry should use it. That means your idea, your patent or your product, your process, your service should be applicable to the industry. Compulsory they will ask. Now, research kind of things will not encouraged here under the patent. There are some faculty also. So what I want to say is research is different. Research will help for the research community or scientists community. But research can be converted into commercialized product. Such research can be patented. Andre compulsory we have to say the invention should have industrial applicability. It should convert into large quantity. Then patentability defines it is comes under laws. There are some guidelines are there. So what you call like acts, patent acts. Under that it should be. For example, this all things they will take care. The patent office will take care. Okay. Then patent disclosure, anything you should able to disclose it. See, soap formulation, I should disclose it. What is that composition ಏನು ಅಂತ ಇಲ್ಲ ಅದು ನನಗೆ ಹೇಳಕ್ ಬರಲ್ಲ ಅಂದ್ರೆ ಅದು ಪೇಟೆಂಟ್ ಕೊಡಲ್ಲ. Everything you should able to disclose it. ಹೆಂಗ್ ಮಾಡ್ತಾರೆ, ಏನ್ ಮಾಡ್ತಾರೆ, ಏನ್ ಹಾಕ್ತಾರೆ, ಎಷ್ಟು ಹಾಕ್ತಾರೆ ಎಲ್ಲ ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಬೇಕು. ಅದು something if you write one app, one program, then you should able to say that each and every step there. That is what we call disclosure. So these are the 5 requirements of the patent. But also we should remember there are limits for this patent. What are the limits? Means time and space. Only two basic limitations. Time indicates in India only maximum 20 years will be given to this, that authority rights. You can enjoy that. That's the time limit. After 20 years of one day, it is not yours. That is a limitation we say. Another one is space. For example, if you apply in India, only it will be protected in India. If you apply for European countries, it will be protected only in European countries, right? Wherever you apply, it will be restricted to that space only. If we apply for India and America, other countries, they can use it. Okay? So these are the 2 limits. And the next question becomes what can be patented. Okay. So I said what can be patented. Some examples I will take it here. Those criteria, these should be, you should have these requirements to patent. Then what can be patented? It must be novel, it must be useful, it must be non-obvious, it must be forceful, that is we call for person having ordinary skill in the art cannot be found in a single or reasonable combination of patents that would yield a predictable results. What cannot be patented under law of nature cannot be patented. Scientific principles, basic principles, you cannot patent it. Even in our biotechnology, whole organism we cannot patent it. For example, if I have discovered a new organism whole, but on whole organism they are not giving it. For example, bacteria, I have identified a new bacteria. Then that whole bacteria they are not giving a patent because that one bacteria which I have discovered may be having different properties, but let others to do it. Okay, but what can be my innovation means that bacteria, what quality you have identified in that bacteria. For example, it is producing lipase enzyme. Then only patent will be given for lipase enzyme production property of that bacteria. That is only, it may be having other bacteria. So that means others can use this bacteria for other enzymes for other purpose. So whole organism cannot be patented. And in the nature, whatever nature comes under natural, no, those things cannot be patented. We cannot snatch the nature. Okay, and scientific principles. This is the principle where this concept works on this principle. So that principle you might have derived, but that whole principle cannot be patented. You will be rewarded, awarded for that. Nobel Prize can be given to that, but it cannot be patented because that principle, let everyone use it. They cannot buy from you because on that principle there are many concepts working. So whole principle cannot be patented. Then simple steps are there how to get the process of this patent. First, we have to file the application. There is a prescribed format for submission of the application. Patent filing we call the first step. There is patent IPO, that is Indian Patent Office. His website is there, Indian Patent Office. We can download that file format. See, two things are happening here. IPR is like property rights is given. There is law under this. Okay. And suppose, for example, I want to apply, I want to take this patent, means I have done the research, I want to apply for this, means there are many attorneys are available. You can also do it. See, government will say you also do it, but when you see the formats, there are all legal terminologies are there because it is a legal work. So those legal terminologies as engineering faculty or students will not be understanding it. So better to give it to some lawyer. Who is that lawyer? Is a patent attorney we call, a patent agent. There are many people who have done the course on this patent laws. Patent attorney we call. Certified people are there, like a lawyer. Okay. So better to give him some fees we will take, let him take. My suggestion. Otherwise, but for students who want to learn, you can also undergo that certification course. 3 months, 6 months online courses are available. You can take that. But if you are interested, otherwise better. Lawyer work, lawyer has to do, not engineer. Right? My suggestion. There are people who will take it, but we should know we should understand what are the what is the procedure to take this patent, how to apply, any steps on them. So there I will tell you. This is first step is application you have to file according to the format. Okay. Then this file will be scrutinized by the patent officials. Patent officially, there are many people, officials. So this will be scrutinized. And they will assess all this criteria, all this there, how whether industrial application is there, novelty is there, all those things they will check it. So if it is unsuitable, they will return it back to the inventor. Or they may ask you to withdraw. Or they may ask you to resubmit. Or with some modification. They may suggest, they can also suggest it, but modification you can do and you can resubmit it. That provision is there. Otherwise, that can be rejected, one step. Another step, if suitable for patenting, if you meet that criteria, all the criteria, your application meets all the criteria, then it will be next step is publish. Publications we call. That means in the publication, everything we are disclosing on the patent office website. This is a journal type things. Everything will be published. So 18 months is a holding period, but now there are many schemes are there. For example, if any woman, girl name is there, woman name is there in the patent, on fast track they are taking it. That is some what encouragement for a woman to apply for the patent or get the patent. So on fast track they are taking within 6 months they are giving the patent. But otherwise, ordinary means 18 months after publication. Just we have to wait for this. Okay, after 18 months it will go to the, they are not giving any technical things here, just they will publish. Why this 18 months? If anybody, for example, I am claiming is that this soap is my, I have developed at my formulation, it is my work anta. Maybe in some other corner of the India people are already using the same formulation for the same application, they may put an objection. For that this period will be given. Industry people will be always watching, every day they will watch ಯಾರ್ಯಾರು ತಮ್ಗೆ ಏನಾದ್ರು ಪೇಟೆಂಟಿಗೆ ಅಪ್ಲೈ ಮಾಡಿದ್ರ ಅಂತ. ಯಾಕಂದ್ರೆ I said no, my soap today if I have applied, some other is doing, I don't know he is doing it or not. I have published it openly, means IP department will publish this. Any objectors are there, then they have to go there. Otherwise ಯಾರೋ ಮಾಡ್ತಿರ್ತಾರ ಅವ್ರಿಗೆ ಗೊತ್ತಿರಲ್ಲ ಇವರು ಹೊಸಾದ್ ಹಾಕ್ಯಾರ ಅಂತ ಹೇಳಿ. ಅಂದ್ರೆ the rights, he will be losing that right, remember this. That's why industry people always they have one people, some people every day ಏನೇನು ಪಬ್ಲಿಷ್ ಆಗ್ತೈತಿ ಮತ್ತೆ ನಮ್ದಿತ್ತು ಅಂದ್ರೆ ಆಲ್ರೆಡಿ ನಾವು ಮಾಡಾಕತ್ತಿದ್ವಿ ಅಂದ್ರೆ ಅವ್ರು ಅದಕ್ಕೆ ಅಬ್ಜೆಕ್ಷನ್ ಮಾಡ್ತಾರೆ. Suppose if it is objection or challenge we saw call, so within 18 months lock period, then they have to object it. Otherwise it goes to the next step, goes to the examiners. So examiner will sorry, I'll just here itself I'll explain. Examiner will thoroughly undergo this your all the details. Examiner will be subject expert. Then if any questions are there, then he will raise as a first examination report. Another again, just he will write the report, first examination report. We have to justify that. Suppose if it is not justified according to him, again he will send second SER we call, second examination report. And then also you are not satisfied, he is not proved for his question, then it will not be awarded. ಅದು ಪಬ್ಲಿಷ್ ಆಯಿತು ಅಂದರೆ ಅವಾರ್ಡ್ ಆಗ್ತೈತಿ ಅಂತಲ್ಲ. ಪಬ್ಲಿಷ್ ಆದಮೇಲೆ 18 months ಆದಮೇಲೆ it goes to the examiner, then he raises the questions. Examiner will be subject expert. So first time SER, FER, he may. Then after that, if he is satisfied, then last step now they are calling for the hearing. Hearing means, like hearing means I have to answer him orally for his answers, not in the writing form. So there, if I satisfied his all the questions, then it will be sealed, awarded or sealed. Nimage award ಮಾಡ್ತಾರೆ. Okay, that is one side. Other side, if somebody challenges, no, this is not his invention, already I am doing it ಅಂತ ಪ್ರೂವ್ ಮಾಡ್ಲಿಕ್ಕೆ ಬಂದ್ರು ಅದರ objection time ಅಲ್ಲಿ, then if he challenges, then argument and counter arguments will start. Proving, I say it is mine, but other side he is going to prove that it is already we are into that. Okay, then if he proved it is already been done, then I will not get the patent. So counter argument and counter arguments will start. Then finally the patent official will take the decision. It is like a court. Judgment will be by the patent officers. Okay. Then who wins? If he other part, counterpart will win, then I will not be getting the patent. If he failed to prove that, then I will be getting the patent. Okay. I hope it is clear. Just this patent search before applying, you have to search the patents, prior art search we call, or patent search we call. Prior art search is like we are going to see whether this is already been published or not. Adu exercise we want to do it. Okay. Then we have to file it, prepare the patentability report, all this overview application. This is again the same procedure, okay, in a different way. Okay. So that is about patent. What I said is what is patent, which can be patented, and which can be how it can be applied under. Then the second form of the IPR is trademark or service mark. We know that trademark, trade secret, Coca-Cola. This Coca-Cola, what we have written is a trade secret. So this is his identification. Nobody can copy it. So trade secret is not like a patent. It is also innovation, but people will not disclose it. But we say if we go for patent, my rights will be officially protected. But ಯಾರು ಲಕ್ಷ ಇಡ್ತಾರೆ, ಎಲ್ಲೋ ಮೂಲ್ಯಾಗ ಯಾರೋ ಒಂದು ಮಾಡಕತ್ತಿದ್ರು ಅಂದ್ರೆ ನಮಗೆಲ್ಲ ಗೊತ್ತಾಗ್ತೈತಿ. ಗೊತ್ತಾಯ್ತು ಅಂದ್ರೆ ವಿ ಕ್ಯಾನ್ ಗೋ ಫಾರ್ ಅಬ್ಜೆಕ್ಷನ್. ಗೊತ್ತೇ ಆಗಲಿಲ್ಲ ಅಂದ್ರೆ, ಯಾಕಂದ್ರೆ everything I have disclosed it. Somebody is doing soap where I will check it. For that, many industries they will go for secret. They will keep secret. ಬಟ್ ಅವ್ರು ಅಷ್ಟೇ ಟ್ರೇಡ್ ಸೀಕ್ರೆಟ್ ತಗೊಂಡ್ಬಿಡ್ತಾರೆ. ಆ ಸೀಕ್ರೆಟ್ ಏನು ಫಾರ್ಮುಲೇಷನ್, ಕೋಕೋ ಕೋಲಾ ಫಾರ್ಮುಲೇಷನ್ ಏನು ಅಂತ ಎಲ್ಲಿ ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಲ್ಲ, ಎಲ್ಲಿ ಡಿಸ್ಕ್ಲೋಸ್ ಮಾಡಲ್ಲ. They keep this as a secret. Actually, trade secret is not so important, but they claim it. ಯಾಕಂದ್ರೆ there are some terminologies where the industrial weightage will be improved. Okay, so for that they will take it, but it is not protected. Okay, so trade secret maybe for individual, for organization, it will be given. Then trademark also. If you see this, it is ISI trademark. Nobody can use this. This is a recognition. Similar Tata, they'll use only this. If you have this trademark, this will be protected. This trademark cannot be used by any others. Okay. Then what is plant breeder site andre? This is given for the new plant, hybrid plant they are coming out. New plants. Correct? Now tomato breeders. This is exclusively rights for the breeders, plant breeders. So they will come out with a new hybrid plants are there, no? New varieties. Where existing, for example, tomato. Tomato actually, the pink tomato if it comes, capsicum, yellow capsicum, pink, red capsicum. So all these are different varieties. So those rights will be given for plant breeders. I'll not go in detail because many of may not be there in the plant breeders. Then this is very important because copyright, all our software related things comes under copyright. Copyright is protects from the expression rather than the subject matter of the writing. This is copyright is not limited to 20, it is 70 plus years. Life plus 70 years will be given. Whatever your lifespan is there, after that again 70 years. So it is the protection provided to the author for his original work of authorship. Script and tantivalla, those scripts will be copyrighted, and books, they comes under Copyright Act. So if a book is written by you, it is your intellectual, you have written the book, this comes under Copyright Act. That same book cannot be multiplied by others because this is already under rights of a person who has made an effort to write it. It's the authorship given. So it comes under Copyright Act. Okay. Similarly, literary, drama, music, arts. In our biotechnology, it is like sequence. A new sequence, if we made now with biotechnologists, then they can take that sequence as a copyright. The symbol will be written like this, and the copyrighted extension can be written. Copyright is maybe recording, maybe broadcasting, audiovisual works, computer programs, digital databases, all this comes under this, but it must be fixed in a tangible media of expression, but which are not protected under copyright means unrecorded choreography, slogans are not protected, short names, titles, familiar symbols, ideas, procedures, these all are calendars, not comes under copyright. Okay. And this geographical indication is, of course, it is not comes under IP, but it is a kind of protection even for the region. Okay. So Darjeeling tea is for Darjeeling people that it is given. Ilkal sari, Dharwad peda, Mysore silks. So these are given not for an innovator or an individual, but for a region. That will not be coming under an IPR, but it is a protection for that zone. Ilkal sari is exclusive rights for the illegal people. Darjeeling tea is exclusively for Darjeeling people. Others cannot make it. Okay? So what are the benefits of IPR? It encourages and safeguards the innovations. It encourages R&D efforts. Why we go for as a teacher, as a faculty, why I go for this? It is encouragement for my R&D work. Okay? So this just I will stop. This choice of IP are not required. So if you have any questions, here I will stop. Yeah, students, if you have any questions, you can, or any teachers also.
I have a simple doubt.
Yes, yes, yes.
If we have a product like, say for example, the instance Udinkadi, what we call it, Intel sticks. So multiple brands can be made and that can be applied for the patent.
It is a new sticker.
This Udinkadi, ma'am, that with waste product of flowers, if it is made.
Huh.
So if
You can claim it. You are making one new product by utilizing the waste, right?
yeah. Mm.
Huh. So what is that product you are making
Mm.
and what is its applicability? Whether it can be converted into many sticks or whatever a product you are doing it, it should be commercialized. If
Mhm.
you can do it, yes, you can. Different brands, no, that will not come under IP actually.
No.
Marketing under comes under marketing strategies. If you want to make it a different brands, you can, you have to change it. For example, Horlicks.
Mhm.
Horlicks, mother Horlicks is different. The Horlicks for 6 months baby is in different, 2 years
Yes.
baby is different, 5 years baby is different. But everything is Horlicks.
Mhm.
What he claims there is for 6 months baby, what is required is added in that Horlicks. The calcium Horlicks is like that Horlicks is exclusively for a mother. That means she needs more calcium, as we call mother. Mother is having a deficiency of the calcium. So he claims he made a one product, but all products are just fortified. Basic raw material is same.
Okay.
That way you can. For all brands, you can have a patent.
Yes.
See, just our mobile now, Nokia mobile was there, right?
Yes.
Previous to this Samsung or other models, Nokia was very famous.
Yes.
But now, no, where is Nokia in mobile?
Mm.
Why it has happened? Andre, ಫಟಾಫಟ್ ಸ್ಯಾಮ್ಸಂಗ್ದವ್ರು ಒಂದು ಥೌಸಂಡ್ಸ್ ಪೇಟೆಂಟ್ಸ್ ದೇ ಅಪ್ಲೈಡ್ ಎಲ್ಲ ಪ್ರತಿಯೊಂದಕ್ಕೂ ಒಂದೊಂದು ಪೇಟೆಂಟ್ ಅಂತ ಅವ್ರದ್ದು these components, the software, whatever, I don't know exactly what, but nobody can copy it ಅಂತ ಹೇಳಿದ್ರು. Then Nokia failed to copy it or do it. That has happened. Yes.
Any other students questions?
Ma'am, good evening, ma'am.
Yeah.
Ma'am, just a small doubt, ma'am.
Yes, yes, tell me.
Ma'am, there is already a boost which have its own patent, ma'am.
Huh.
If I change the sugar content of a boost and reintroduce it in my own company name, can I?
No. Because what is the inventiveness there? If you're just changing the composition, you are
Yes, ma'am.
not
Just
avoiding the sugar completely, just composition you are changing. That
yes,
is
ma'am.
not called as a inventiveness. Suppose without sugar, your product is in boost, there is a sugar content. It cannot be used by the diabetic people. Suppose if you come out with the same boost, sugarless, but just not composition changing. Andre, then if people like that, yes, you can have it. Got my
Yes, ma'am.
point?
Yes, ma'am. Thank you, ma'am.
ಬಟ್ ಓನ್ಲಿ ಥಿಂಗ್ ಈಸ್ ಅದು ಯೂಸ್ ಆಗಿರ್ಬೇಕು ಯಾರಿಗಾದ್ರೆ ನೀವು ಬರೀ ಕಾಂಪಿಟೇಷನ್ ಚೇಂಜ್ ಮಾಡಿದ್ರೆ ಅದು ಪೇಟೆಂಟ್ ಅನ್ನಂಗಿಲ್ಲ.
Yes, ma'am. Thank you. Thank you, ma'am.
ಎಸ್
Nice information, madam. Thank you.
ಇಟ್ಸ್ ಮೈ ಪ್ಲೆಜರ್ ಮೇಡಮ್. Yes. So now India is boosting or India is encouraging for IP because we need it. We Indians need it and we want to prove that we are able to create many things. We don't want to depend on other countries to produce the product for my purpose. That's why these all are encouraged. Okay? Yeah. If there are no questions, shall we wind up?
Yes, ma'am.
Yes. Thank you. Thank you one and all.
Thank you, ma'am. In spite of your busy schedule, tomorrow NBA visit is there. I think still you have to be in the department for all the preparations. Thank you for making us to know about the basics of the patent, how the types of patents are IPR is available, and also the procedure, how to apply it, and how actually we have to initiate for going for this patent application, that you made us to know in a very simple way that where everybody I think can easily understand and catch it and can remember the things how if they in future if they want to go for any kind of this patent application. With this, once again, on behalf of IIC Bishwesh Engineering College, I wholeheartedly extend my warm gratitude to our resource person, Dr. Bharti Reshmi ma'am, for being with us for almost 1 hour for sharing the overview of IPR. Thank you, ma'am, and thank you all the audience for being a part of this online session. Thank you. We shall exit now.